hearing remotely. So this is her ex parte application for relief from the judgment that was entered yesterday. And the total amount of the judgment was $22,519.44. Mr. Shu, have you seen the defendant's paperwork?
Yes. I would suggest that if the defendant is willing to post that money to court, I can suggest to my client who are willing to set it aside. If Ms. Joseph would like to address that, that would dictate my next course action.
Sure. And so, Ms. Joseph, did you see the plaintiff's opposition?
I didn't. They didn't send it to me. But, Your Honor, I rise to make an oral motion for judicial notice. As I respectfully request the court to take judicial notice of certain facts and documents that are completely relevant to the case. The first being that I did not contract with Mrs. Holguin or Mr. Louis Corrado, and I still haven't, and they have absolutely no firsthand personal knowledge of the facts. I have not seen any signed declaration from the actual plaintiff, and he hasn't testified. I haven't seen a deed, a trust from the principal for this property, proving he indeed is the owner of this property or the landlord. There's no adequate legal proof. I want to also have the court take judicial notice of the revised guidelines to aid in the implementation. I'm sorry, let me cut this off. I'm sorry. I've never done the call-in. Implementation of the LA County COVID-19 tenant protections that were extended on June 2022. I did submit these as attachments and exhibits. There's no substitute for enforceable rights and robust protections, which I have and I assert. There's a prohibition, and there was a prohibition on evictions, and I fall under it. I gave more than enough evidence, and I'm requesting judicial notice of that. I also request the fact that Microsoft Teams has been having issues for days, and I did not and will not waive my constitutionally protected rights. That is being a jury trial. So I'm not sure how the jury trial happened the other day, but there was no possible way it happened in 2 minutes. I was disconnected, and I was told that I'm sorry. I have the absolute right to talk, and I'm going to continue. Please take notice that it's alleged the court contacted me many times on June. I'm not done.
Ms. Joseph,
I am not done.
Okay, I will give you a chance to be heard further, but you're raising a lot of issues at once. Okay, so let's take them a little bit at a time. I know you want to say everything all at once, but it's not going to work that way. Okay, so I will give you a chance to finish what you want to bring up. What we have on calendar today, what's on calendar today is your ex parte application for relief from the judgment that was entered yesterday. Okay, so Ms. Joseph,
I apologize. I will.
So the request for judicial notice is denied because it has to be in writing. But I will look at the items that you're talking about.
That is actually incorrect, Your Honor.
Ms. Joseph, for the court to consider them, you don't have to do it by request for judicial notice. So I'm looking at your ex parte application for the items that you were requesting judicial notice of because you said they were attached. Were they attached to ex parte for today, or were they attached to something else?
They're in my case, but everything's been overlooked and ignored as have I.
Ms. Joseph, they're in your case. When did you file it?
I've filed so maybe we should take judicial notice of the actual exhibits and facts and evidence on here because I'm the only one that's provided any.
So Ms. Joseph, so the request for judicial notice is not really the way for you to proceed right now. If you want to file a written request for judicial notice, you can go ahead and do so, but there's no trial on calendar now. The only thing on calendar right now is your ex parte application for today, but as I indicated, the court can consider the items that you're requesting judicial notice of. You just do not need to do it through a request for judicial notice. But if you just direct me to what day you filed it, I will look it up. I've got the electronic version of the file, and I will look it up if you tell me what day you filed it.
So I do know, for the record, my motion to strike was never heard on Tuesday, nor was my motion to dismiss. So I raised that again. My motion to dismiss still stands, and those are attached on the motion to strike and the motion to dismiss. Unfortunately, I couldn't print out.
Ms. Joseph, hang on a second, okay? So yeah, those were ruled on yesterday. So the motion
they were not. For the record, they were not.
Oh my goodness, Ms. Joseph, let me finish, please.
You are interrupting me, so I would like to remind the court of Canon 1, a judge shall uphold the integrity of the independence of the judiciary. You have deprived me of my rights. You are speaking over me. You have not read my pleadings. I have protected
and I was telling you what the ruling was on them yesterday, so you should
It
hear
wasn't
me out.
yesterday.
Ms. Joseph.
I wasn't yesterday.
Ms. Joseph.
For
You should hear me
the
out.
record, the trial was July 18th, 2023. I will correct you, so I'm not railroaded further than I was. I do not waive my rights, and you have trampled on mine.
Ms. Joseph,
For the
take
moment
one at a
of the
time.
women
Ms. Joseph.
that you took it over to.
Ms. Joseph, all right, let's put this case on second call. We'll call it again in a few minutes. Okay, calm down, Ms. Joseph. We'll second call.
I think you need to calm down, Your Honor.
We'll call it again in a few minutes. Please. We'll
Until you
do this again.
disconnect
So, Ms. Joseph,
over
Ms.
to
Joseph.
the trial.
All right, second call. Second call. We'll call it again in a few minutes. Under CCC 1179. So Ms. Joseph, in your application, you were offering to pay April, May, and June rent, and you mentioned paying the July rent. The plaintiff in their opposition is saying that they are seeking the full amount of the judgment that was entered yesterday, which is $22,519.44, which starts back in October and goes through January for the past due rent. That much was $8,800, and then the holdover damages pick up in February through July. So Ms. Joseph, did I read your paperwork correctly that you're offering to pay April through July at this time?
You read my paperwork correctly, but I again want to, for the record, state this is a breach of contract, complete retaliation, and I am 100% covered under the COVID moratorium, which means this unlawful detainer, I want to state for the record, I am not in unlawful possession of any property, and I don't even know who owns this property. So, for the record, and it's not my job to educate the court on local ordinances, but I did, and I have, and I don't know if, apparently I can't make a judicial notice orally, so for the record, my amended unlawful detainer contains all of the information necessary to back up my claims. Also, for the record, the only claim in this that has been provided or evidence is a signed lease that was actually inaccurate from the beginning. So this is completely fraud from inception. I do not owe that amount of money, for the record, and but what you are reading is correct. Like I said, I am sick. I am tired of being harassed. I've been harassed by these people for a very long time, and I just need to breathe. And I have been offering them money since January. Following the 3-day notice, I went to the home that was stated on the 3-day notice, pay rent to no avail. And I also want, for the record, to say when I was doing the motion to quash, I apologize, the motion to quash, when I filed that, I was hung up on before I was actually heard, and the 3-day notice, in fact, is actually defective because it told me to pay Anthony Holguin in person at the address listed, in which I did. However, you come to find he had been in prison that whole time. It was defective from inception, and this shouldn't have been able to be filed until April 1st, 2023. I looked up where the documents are. Unfortunately, I did bring the COVID. Let's see, I have it in my hand somewhere in my paperwork.
So Ms. Joseph, I'm glad you got a list of everything you want to bring up, but do we address them one at a time because I don't have that list, okay?
Yes, absolutely.
Okay, so you're saying the complaint was filed prematurely, should not have been filed until April 1, 2023?
100%. And I had been trying to pay rent that entire time.
So, Ms. Joseph, what I'm looking at is that the complaint was filed January 26, 2023.
Yes, exactly.
Okay.
Did I hear you incorrectly? I apologize if I did.
No, I'm just trying to understand what your position is here. So let me take a look at the file and see what the correct file is. So of the complaint by January 26th would have been timely.
No. They extended the moratorium, and pursuant to California AB 3088, stating that any unlawful detainer based on non-payment of rent is not to be filed until April 1st. In addition to those protections, before being able to file, they have to be 2 months past rent, and they require a 15-day notice. But the fact is...
So, Ms. Joseph, can you tell me what section you're talking about? When you talk about the 15-day notice?
So I don't have that in front of me right now, but I do have on page, I believe it's in my motion to strike because I provided just that page under C, I believe it's page 8, repayment, residential tenant and able to pay rent incurred from April 1st, 2022 through May 31st, 22 has until May 31st, 2023. It's unless it's extended further, which they're actually talking about right now. Let's see. And then if you're 80% area median was unable to pay their rent, so I have that attached on one. Sorry.
You attached it to what?
I know that this paper is attached to my motion to strike, but I have a lot more attached to my amended UD, and then wait, I have a information.
There are a lot of issues here, Ms. Joseph. Why don't we go, now that you brought up the motion to strike again, why don't we go back to that for a moment? Motion to strike and motion to dismiss filed yesterday were denied. So,
for the record, I wasn't present for that hearing, and I didn't get to argue on it.
Let me tell you all about it.
Sure.
Let me tell you all about it. Okay? So motion to strike is untimely, needs to be filed within the time to file responsive pleadings after the summons of complaint is served on you. And the motion to dismiss was not based on Code of Civil Procedure section 83.010. So the motion to dismiss that you filed was only for limited grounds and the grounds that you were asserting were beyond that.
Okay, then I orally motion the court for 583.010 Civil Code of Procedure. Motion to dismiss.
Those don't apply.
Okay, and I also would like to object to that.
Those cases filed in January. Those cases talk about, when a case is 2 years old, 3 years old, 5 years old. This is not one of those cases.
Okay, I understand you're not an attorney and can't give me legal advice, but I'm not an attorney either, and I don't speak legalese, but I do speak morally, truth and honesty and right and wrong, and I'm telling you that, I'm letting you know that this is fraudulent. I'm telling you that I don't understand the code and all that. But I do want to...
Ms. Joseph, let's go back to the other point that you were making, saying that instead of a 3-day notice, there should have been a 15-day notice to pay or quit. So the 15-day notice requirement has expired, and 3-day notices are now valid again.
Correct. After May 31st, 2023. However, that's not even the issue.
No. It expired, Ms. Joseph, it expired before that.
Okay. So I also would like the court and for the record to know that I have reported this fraud to the Department of Justice, the OIG, and the Board of Supervisors, because it is the Board of Supervisors' job to ensure that their judicial bench officers are aware of all applicable anything that's been extended, and that they are educated and knowledgeable about everything. I've been railroaded this entire time. I really want to be able to speak for the record.
Ms. Joseph, earlier you mentioned that it was not your job to educate the court, and that is true, but I do need to know what section you're relying on. So if you're making a proposition about something that's required or something that the plaintiff did not satisfy, you need to let me know what section you're relying on to make that point, okay? And Ms. Joseph, tell me it's been filed somewhere anywhere. I've got the electronic file right here, and I will look it up, okay?
I don't have the electronic file right there. I have provided everything. Can I please see it?
Ms. Joseph, did you tell me when you filed it and when you attached it to, I will look for it. I do have your amended answer here, which has some attachments to it. I've got your
I'm trying to speak, but like an emotionally deregulated child, I am being spoken over. I don't have it in front of me. I can't come back today at the end of the day because I have a meeting with my son's teachers. I have filed enough evidence to prove my point by the court of law. I need to be able to speak.
Ms. Joseph, so if you want to prove your point, let's take it one point at a time, and let's talk about what law you're relying on and what evidence you've got, okay? But what's on calendar for today?
For the record, I am not being allowed to speak.
Ms. Joseph, what's on calendar for today is your ex parte application on a motion for relief from forfeiture under TCP 1179, okay? So you got a lot of other issues you want to bring up, and that's fine. We can look at some of those, but perhaps we don't have time to look at them all, and let's stick with what's on calendar for today.
I understand, but for the record, I need it known that I'm being spoken over, and I'm not being allowed the opportunity to speak, which means that I am not being provided equal protection of law, and I demand it.
Ms. Joseph, let me just say that, so we've been on the record for a long time today on this matter. You want to go for 5 minutes? I'll give you 5 minutes without interrupting you. Go.
I don't want 5 minutes, but I just want to be able to speak, and it appears that we are...
Objections are being spoken over. I promise I won't speak over you for 5 minutes if you want to go ahead and speak. But you've
already failed.
I find it more useful to take it one matter at a time. You tell me what code section you're using, what evidence you're relying on, that's fine. But let me get back to the main issue here today, which is your ex parte application under CCP 1179, relief from forfeiture.
Okay, I understand.
You want to talk about that?
I have yet to be able to have that 5 minutes uninterrupted.
Okay, you want 5 minutes? Go.
Thank you, awesome. So if we're taking it one step at a time, I should be provided the opportunity to speak after each one section at a time. So that brings me to the motion to strike, which, upon providing new evidence of fraud, the court can, on its own motion, strike whatever they want. The same goes for the motion to dismiss. And again, I provided the evidence. As far as the evidence, I don't have the electronic in front of me. I'm trying to pull it up. But I understand that the court is not going to wait for me, given what happened on, not yesterday for the record, because it keeps being said that it was yesterday, on Tuesday. I'd also like to point out that I've heard you guys look for people like 3 times today. Oh, is this person in the hallway? Oh, this person signed in. But she didn't wait 30 seconds for me on Tuesday, and I never waived my right to a trial by jury. And when you deprive anybody of their due process rights, then the whole entire thing should be dismissed. The void judgment is one from which its inception was a complete nullity, and it has no legal effect. So this should be dismissed on that alone. We don't have bill of attainder, and you guys have completely violated my rights. Also, for the other attorneys and for the record, you guys are in breach of your fiduciary duty because on Tuesday you were well aware that we were trying to contact you per the emails, per the calls, per the voicemails. So back to today. Yes, I am willing to pay. However, I still am going to argue and fight that this is fraudulent because it is fraudulent. And it was fraudulent from its inception. So as far as today's motion, I did state that I desperately need relief from forfeiture. I am willing to pay back from April. I may need time, not a lot of time, but time to see if my boss will give me some of that. But I can pay my rent for right now, probably, is tomorrow Friday, by the end of tomorrow. In whatever manner they, that is wanted or whatever. And if you want me to pull up and, tell you exactly where things are, I can. I just need a moment.
Okay, go ahead. Look, if you're having any luck pulling it up, please keep trying.
I'm sorry, I missed that.
Keep trying to pull it up if you're working on your computer.
Okay, yes, I am. I'm trying to log into the system that I file some of this stuff in.
And you're absolutely right. We were having all kinds of computer problems, and you're right. It was July 18, not yesterday.
Okay, let me see. Okay, so I have. Let's see what my amendment. I have that. My exhibition. So, as far as the amended COVID thing, I don't know what access the computer in front of you has, but I can. Is there someone I could provide, or maybe you can look? It's the extended guidelines of the eviction moratorium signed by the Board of Supervisors.
Oh, so you're talking about the county?
So yeah, that's one of them, yeah, but I have the amended one. I didn't attach the entire thing, but I did attach the relevant pages.
So what part of the guidelines are you relying on?
Well, I'm relying on the fact that they shouldn't have been able to even file this until April 1st, 2023.
So is the one specific guideline that says that you're looking at?
So here's another thing, and I know that I've already stated it, but again, for the record, I filed previously restraining orders against Claudia, Holguin, and Louis Corrado. I started in November of 2022, and then when the attorneys on their case came in, they basically wrote and said that it was in retaliation of the UD, even though it was filed prior, and just given, and I didn't want to hurt anybody, so since they had attorneys and they were going to stop bothering me, I just let it go, but they read the entire complaint stating that I was being harassed and it was so stressful, and they kept leaving and sending me things, in which the Dennis Block law firm has sent me paperwork over and over and over again. The same exact paperwork nonstop since they have represented plaintiffs. Okay, so Rule 8.2C, and then there's phase 2 and 3.
So that sounds like part of the county code that applies to unincorporated areas only.
It applies. Some of it applies to unincorporated areas only, but it doesn't. The whole entire thing, because I reached out to the board of supervisors, applies to the entire county of LA. However, the incorporated counties can make their own and additional protections, and that's why it's so difficult to evict people in LA City, because of the additional protections. But you can't take any away. So, and then I have, okay, so this is just stuff that's written correctly. Sorry. Let's see. Pages 9, 15, 16. And then I have attachments to my motion for a new trial, which basically has my evidence and.
What was the new trial file?
I'm sorry, I have the actual paperwork in front of me. I don't know when if it's an ex parte, then it was July 2nd, maybe? Which includes that the lease attached to the complaints that they filed wasn't correct, and then it also said I was month to month, and that's not correct. I have a lease until April 2024.
I see on July 3 there was a motion for reconsider. Oh, it's a notice of intent to move for new trial, July 3. And then that and that judgment was set aside though, right? Like around July 8 or so.
Yeah, but I'm just pointing out that there's I have the exhibits and attachments to that, some of them.
All right.
And then I'm still looking to find exact dates for the other ones. I have a lot of paperwork.
Right. So let's try to figure out which ones to rely on so we can talk about that.
Okay, the notice.
With the California Supreme Court right now, because of this situation, there is also an appellate case right now, and there's also a federal lawsuit.
Just to note, I also provided information that I had requested repairs, that I had called the county, that I lots of that kind of stuff, all prior to this.
Online, you'll see a federal case, Emmer versus Penna,
And then it was alleged I was not communicating. I provided the receipts from my communications from the USPS. Also the.
So getting back to what we have on calendar today, your ex parte application on a motion for relief. So that can be done, but it depends on paying the months that were listed in the judgment from July 18. And so the plaintiff is asking for $22,519.44. How long do you think it would take you to bring that current?
I do not owe $22,000, and it'll probably take a week or two for me to get some contact back from the Department of Justice and the OIG in regards to that. So I think that I should probably have a fair opportunity to be able to figure out what's going on with the federal funds.
So the other thing that the court can do is issue a stay under Code of Civil Procedure sections 918 and 1176, which would give you 40 days from July 18. That's August 30. And it requires you to pay rent during that 40-day stay, and that would be $2,933.20.
Let me write that down. That doesn't waive my right to file for relief from forfeiture in the future, does it?
So what you're telling me now is that you're not willing to pay the amount of the judgment?
No. I didn't say that. I was getting a pen to write that down. I was asking a question in the instant. I am absolutely willing. I've been willing since January. So one thing at a time.
You were saying not the $22,519.44 that was entered in the judgment on July 18.
Yeah, absolutely not. It's fraud. I don't owe that.
All right.
But I'm willing.
The amount that we're talking about now, for a 40-day stay, $2,933.20, and there's no lockout before August 30th.
I'm just a little dyslexic. $2,900.33.
No, it's not 2,933.20.
2,933.0. 20. Oh.
$2,933.20.
Oh, 20 cents? Where'd that come from? Okay.
That's 40 days rent.
Oh, I see. Okay. And am I paying that up front?
So, can you do that by July 26th, next Wednesday?
Yes.
Okay. So, Mr. Hsu, how would you like that payment made? The way she regularly pays rent?
Correct. And here's the good news is that
do you want to do it the way she usually pays rent?
wants him to do is to basically tell his father and
Does that work?
his family to basically piss off. And so she
Okay, check where you want the check to go.
capacity. So what with his dad's family and friends.
It's FACULTY faculty. Okay, and is that the same address on the as the 3-day notice to quit?
Stay put because we don't
Okay.
want
So Ms. Joseph, when you got the 3-day notice to pay or quit, it had an address on there where you should pay that rent. 5409 Faculty Avenue. What city is that?
Yes. Yes, I went there to try to pay rent, so I have the address. I just want to confirm, am I making it out to Mr. Anthony Holguin or?
Yes. Yes, to Anthony Holguin, the plaintiff. Anthony Holguin has 2,933.20.
Okay, Anthony. Okay.
What city? In Lakewood. Okay, 5409 Faculty Avenue in Lakewood.
Okay.
2,933.20 by July 26th. And so the court's going to issue the stay and notify the sheriff's office and notify both sides. No lockout before August 30th.
Okay, thank you. I appreciate it. I have one more question. If I hear that plaintiff, Mrs. Holguin might be there. I do know that there are repairs. I have filed complaints, and per the stay, I'm willing to, obviously set a date, restrain my dogs so that they could come in and make the necessary repairs.
Yeah.
So again, I think the best thing would be is that if things do go sideways, that he basically right now there's a motion to
Okay.
the court.
This is with the county department. Okay.
Now because he's 16 and he has an attorney with his documents. So he's asked the court already to move in and back in with his grandmother. So that's on calendar to be heard right now. Yeah, so that's on calendar. So here's the game plan, because I gotta go myself, and I really appreciate your time and Vince fantastic work. The good guys, so Belinda
Okay.
is going to email you the power of attorney and the information that she sent to the psychologist, and she's going to CC.
Okay, so Inspector Zamora is willing to come back and re-inspect. Is that what you're saying? Okay. Okay, Ms. Joseph. So the county inspector Zamora is going to come back to re-inspect. Okay.
Okay, sorry, I couldn't hear anything that was said, so I just will take.
Right. That's
okay.
why I'm saying it. That's what I'm telling you. So what she's telling the court is, and you, is that there's a county inspector Zamora who's going to come back and re-inspect.
Okay.
So if you and Ms. Logan would like to be there at the same time. So Ms. Zamora, so if you'd work with everybody to let a re-inspection take place.
Yes, absolutely. I just need a couple of days. I have big dogs, and I just need to find a place for them. That's all.
Yeah.
My understanding is my client had at least twice before tried to extend, three times, tried to extend it, extend it was not cooperative, that's not.
Okay. So so if you do it with the county inspector Zamora, then that should help also. So if you work with everyone, so that can be set up.
Yeah, and I just wanted to state for the record, the reason is because I was sexually harassed by my landlord. I was living in fear, and my family was being filmed, so I was just asking for some time to have somebody here with me.
Okay, and so the motion for relief from forfeiture is off calendar. So Ms. Joseph, if you need to renew that, you can renew that.
Okay, thank you.
And the stay is going to be issued, and both sides will get a notice of the stay as well as the sheriff's office.
Okay, thank you.
All right.
Have a good day.
Thank you very much. You too.
Bye-bye.
Bye-bye.
Your Honor, on number 4,
Yep.
the department, yes, no, all the parties and counsel of both the department and to be heard by judge staff.
Okay. So number 4, De Leon versus Ariana. So Mr. Shute, do you have anything else in here? Is that your last matter?
No, if that's this morning, I'll be happy to go there. I can
Yeah, go to Department F right now. Judge Lee Sau is going to be in there, and he's the assistant supervising judge, and he will hear the defendant's request to revoke this. There we go. Thank you. All right, third floor. Thank you. 7, Mercado versus Gonzalez. Okay, Commissioner Pezek. And Mr. Katz.
Bryce lived with his grandma for over a year, and they've been really close his entire life. The other advocates, a couple of
I think we put Mr. Katz to sleep. Mr. Katz.
have a really extensive psychology background, and they've known Bryce. So what's nice about Bryce,
Mr. Katz, this is number 7, Mercado versus Gonzalez.
So she actually has the final say specified in the.
Yeah, we might be on another call. Yeah, he's
No, I'm here, Your Honor. Sorry.
Okay, there we go. All right, can I get your appearance?
Jeffrey Katz for the defendant.
Okay, good morning, Mr. Katz. So there's a note here that says it's non-jury trial for monetary damages only. Is that right? Okay. Okay, but possession is not an issue. We have Mr. Katz and Mr. Pezek here with his client to do the trial. Are you ready?
We signed a stipulated judgment here. Let me take a look.
Oh, okay. Oh, possession only, Mr. Katz. Is that right? Okay. All right. But it's what he says, Mr. 20 seconds.
But when it comes to education and that kind of stuff, she's going to defer to some of the other brains.
In awarding possession, judgment entered pursuant to item 6.
Yeah, no, I've listened to some of the recordings. It's heartbreaking. So basically, what happened was
Item 6 says the attachment 1.
Bryce kept calling her and pleading for help. She asked him.
And then paragraph 6 also specifies that the case will be put on the regular civil calendar regarding money damage.
Bryce's mom was running around.
Sounds like that's what we're here for today.
Basically making stuff up. So.
And there are additional provisions attached.
Bryce, of course, said yes, please do, and help me. So then Glenda took those recordings.
Which don't really talk about the money damage at all.
Legal.
So it looks like plaintiffs reserve the right to seek money damages in the stipulated judgment in the past.
All right.
Okay. So Mr. Pezek, you wanted your client to testify to the damages then? So, Mr. Katz, you ready to do that now?
I guess so. I think it'll probably evolve into approval if we go ahead.
Okay. All right, let's swear the witness.
Stand and raise your right hand. Please solemnly state that the testimony you may give in the cause now pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please state and spell your first and last name.
Okay, Mr. Pezek, you may proceed.
We have the bottom three for Oscar Guerrero, Oscar Guerrero, what one is that? That is that which you can send.
Yes, that's correct.
He's really frustrated. He's like having everybody talk and everybody's kind of screwed. And he's just kind of like giving an expert call. And that's all he wants to do is.
I have them in the before.
So we can mark that as Exhibit 4, and for any documents not in the court file, the parties are ordered to retain custody until this matter is final. I mean, one concern is whether or not Mr. Katz has seen that or wants to see that. Mr. Katz, you want to see the power of attorney for the plaintiff?
No, Your Honor.
Okay. All right, so that's marked, the power of attorney is marked Exhibit 4 by plaintiff.
You also the manager for Oscar Guerrero, the owner of the property. And you are managing
What Glenda's trying to say is that Bryce actually filed a police report, so you can probably look that up. There's an incident number, I believe.
Mr. Guerrero versus the property on that week, plus 2023. Your Honor, I would like to go over the planning,
Superior
zoning,
Bryce.
that property was purchased by Oscar Guerrero
up?
Yeah, I mean, I seen all this money. And I would like to mark that as one piece is also attached.
Okay, so Mark.
And is this a true that copy? Or separate? You can do it. And I would like to mark that as a true drawing.
No Mark.
Is because he basically told everybody, you're not gonna put, my son in a facility.
When did they vacate the property? So when you, after, purchase this property, on that, there was a protection of the property.
So luckily, they all backed
And
up,
what
so
is
we
it?
weren't gonna do it, and they're trying to pretend like that never happened.
What's the fair rental value of the property?
It is 160 per day.
And how did you determine that fair rental value of the property?
I will take fair market analysis based on what is on the national and the state.
Right now, yeah, what I'm just trying to say is that the,
Are you the realtor, what's your profession?
I'm a real
so,
estate.
now when we start returning, the court has to let us speak.
And this is true, if they're talking to competitors, market analysis, and those, the ones, the least people that you could property, and
Say no, they don't. The only way they can say no.
you don't know that to mark that, competitive, market analysis, that's fine.
Okay, so Mark.
So we've taken up enough of your time, I gotta get back to work myself, so we'll shoot this over to you, and
So,
then call
there's
you
a
up with
thing,
questions,
any
and then
money,
Lynn's kind of tongue tied,
yeah.
I think what she'll do is hand you off to one of the other people. that
And
is-
you're seeking daily damages today, I think it's $60 per day, from February 2nd, July 9th, 2022.
So I thought you just said Exhibit 2 is a declaration of service that says the notice was served February 19th.
Yes, we know.
But then after that expired in 3 days, that's when the holdover damages would
Also,
start.
that's fine, from February 22nd,
Unless it was a weekend.
July 9th.
Let's see, so, 19th was a Sunday. Yeah, so it would start February 23rd.
February 23rd, July 9th. 6 days, February. They go out on July 9th, on July 9th. They're 137 days. And we did.
So that was great, this is because.
15,000 what?
890.
Okay, the complaint was up to $10,000.
Well, that's fine. Then I'll pay, that.
Okay, so plaintiff's willing to remit amounts above 10,000, they just keep 10,000 in holdover damages? Okay. Okay, anything else?
No.
Mr. Katz, you have any questions?
Well, based on the stipulation, I don't believe there's anything other than the calculation, and since, no, Your Honor, no.
Okay. Okay, so, judgment for, plaintiff, holdover damages awarded, $10,000. Do you need anything else for that? So we have a stipulated judgment for possession. So, can we do it, another judgment? Does that work? $10,000, okay, $10,000 holdover damages. The court will issue the judgment, then both sides will get a copy of it.
Thank you.
All right, thank you.
Should I give you that exhibit here, or?
No, you retain custody until the matter's final. All right. Mr. Katz, do you need to see any of the exhibits?
No, Your Honor.
Okay, all right. If you keep them, that's good. Thank you.